right. Hello, everyone. Thank you for showing up today. I know we're going to have a few people, looks like, are still logging in, but we've got a lot of information to cover, so we're going to go ahead and get started. Before we do that, though, I do ask for questions for Q&A. If you could please use the Q&A function down at the bottom of your screen. We are going to cover the information in chunks, and so as we go, you can put in the questions, and then once we get to a stopping point, Tina and Helica will cover those questions, and then we can move on to new content. So without further ado, I would like to introduce Tina Harkness of the Employers Council, and she's going to cover our 2021 employment law update. So Tina, go ahead, take it over.
Thanks, Vic, and thanks everyone for being here today. I'm very happy to talk to you about what's going on in federal and mainly Colorado law. We'll talk about what the change in administration means and some of those things that are in the works at the federal level today. Then we'll dive into some Colorado changes, a minimum wage change that occurred January 1, a comps order that covers all private employers in the state and what changed for January 1 there. We'll spend some time on the Equal Pay for Equal Work Act and the federal and Colorado different paid leave laws that are or were in place. And then finally, we'll end with some new whistleblower protections. And as Vic said, I'll try to pause at different points, take some questions before we add any new content. We all know that change is constant, but change in the area of employment law has been a little faster paced of late, last year and this year so far, than we're used to. So I do hope that you'll share your questions, that you won't leave here with questions, and we will have plenty of time to get to that information. If not, we'll arrange for some kind of follow-up afterwards. So just to give you a little bit on the priorities that we're seeing from President Biden and the new administration, I pulled these things off of his campaign website. What we're going to see from him specifically, but what we also tend to see from Democratic administrations is more perhaps aggressive enforcement tactics, more pro-worker types of executive orders and legislation than we see from Republican administrations. So we're already starting to see some of this play out. I don't know if any of you read, but the Colorado or the U.S. Department of Labor and Employment had something called the PAID program, and that was an amnesty program for if you realized you made a wage and hour error and did not pay your employees properly, that you could go through that program and you'd still be responsible for paying any back pay that you owed to workers for your mistake, but you would not be assessed any penalty or additional damages, which is available under the federal law. So that program was ended pretty quickly after the Biden administration took over, so that they can potentially litigate those claims if they find that there are problems. I don't know how many employers really use that, because employers don't often want to disclose their mistakes. They'd rather fix it going forward or fix it with their employees and proceed from there. But that's just an indication that they are changing things. Also in the wage and hour arena, there were some tip pooling regulations that were in the works, an opinion letter on what it takes to be an independent contractor that have been rolled back from the Trump administration interpretations, pending new interpretations from the Biden administration. And I think we can expect that fewer people, again, will qualify as independent contractors, and there will be more protection for tipped employees in the tip pooling regulation than perhaps were present from the previous administration. We're also going to see an encouragement of union organizing and collective bargaining. So collective bargaining is the negotiation that unions engage in on an annual or every other year, or sometimes up to 3-year basis for the terms and conditions for those workers. So the Democratic administration has the support of unions, and they want to work with unions. We've already seen some pro-union legislation being proposed in the House of Representatives, and we'll see that continue throughout the next 4 years. I've also seen some information about eliminating or restricting different kinds of employment agreements that employers might want to enter into, particularly non-compete agreements, non-solicitation agreements, those no poaching kinds of agreements that we might have with high-level individuals in our organization, and arbitration agreements. And we've got some really good Supreme Court authority to say we can have mandatory arbitration agreements with our employees rather than going to court. But we'll see what the Biden administration does, because they want people to have their day in court if they choose to have it. And finally, we've already seen some increased focus on workplace safety and health. So the Biden administration right away instructed the Occupational Safety and Health Administration, which covers all private employers in the United States, to put out more strict safety recommendations for COVID-19. And we have some of that already. We have some guidance, but you can expect that there'll be more enforcement from that agency as well, dealing with the current crisis and going forward. So diving into Colorado, I just want to make sure everybody has information on some of these changes that went into place 1/1/21. Minimum wage is pretty well out there. We still have a federal minimum wage of $7.25 per hour, although we have had proposed what's called the Raise the Wage Act, which would raise the federal minimum wage in 4 increments up to $15 per hour nationally. That has been proposed previously and has not passed. So we'll see, and we'll track its progress this time. But in any case, we know Colorado has a higher minimum wage than the federal minimum wage, and has had that for quite some time. So we just got through 3-step increases, well, actually 4-step increases, to bring us up to $12 per hour under a constitutional amendment that we all voted on back in, I think, 2016. But even prior to that, there was another constitutional amendment in Colorado that required the minimum wage to be looked at and adjusted each year based on inflation. So now that those 4 steps under the second constitutional amendment are completed, we're back to the annual adjustments based on inflation. So that is where this $12.32 per hour came from, is that adjustment. And typically the Colorado Department of Labor looks at the Denver Boulder Consumer Price Index and makes that adjustment every October. So you see the proposed new minimum wage, they hold a hearing, and then they make it final sometime in November. So we're now at $12.32 an hour. Again, I know Steamboat often pays higher than that, but that is the minimum in Colorado. And then in 2019, you may be aware that Colorado passed a law, or rather rescinded a law, that did not allow municipalities to pass a local minimum wage. So Denver jumped on that bandwagon first and passed a local minimum wage right away. And for January 1/21, that local minimum wage is $14.77 an hour. Now, there are sub-minimum wages that can be paid to employees who are tipped employees. Those are people who regularly receive at least $30 a week, or I think it's $30 a week in tips. And that is a reduced minimum wage that you can pay, with the assumption that with their tips, you're going to be up and over these limits. It's actually $30 a month. So I said a week, I apologize. I should look at my notes while I'm doing this. So that's the minimum wage piece. So that's really probably something you have down, but just to make sure. Then the comps order, this applies to all private employers in Colorado. And I just want to emphasize that because formerly, prior to March of 2020, it only applied to private employers in certain industries. Those were retail and service, commercial support service, food and beverage, and health and medical. So those folks were very used to the requirements of that order. But the order expanded in coverage to all private employers as of 2020 and also expanded in scope. There were some additional things added to the comps order, which is why they changed the name from the minimum wage order number 35. They changed it to comps order 36 because they felt it didn't just deal with minimum wage. So comps order 37 is in effect as of January 1st, 2021, and we'll get a new one every January 1, partially because they're going to adjust at least minimum wage, but they may make other adjustments. One of the other pieces that came with the comps order in March of 2020 was some additional posting and distribution requirements. So we've always had to have, if you were a covered employer, the poster up. But one thing that changed in March of 2020 is if you have a handbook and you're a covered employer, you needed to include either the order itself or the poster for the order in your handbook and have your employees sign a separate acknowledgement of receiving that information. So this is new, and this is something that we're finding at Employers Council that maybe some employers missed and we're not aware of. Now, the language is actually when you have them sign a new handbook. So if you haven't had a new handbook, then you're probably still good as long as you have posted the comps order number 36 last year and number 37 this year. But do make sure when you do your next handbook revision that that gets in there. So the comps order number 37 requires for non-exempt employees, so these are your overtime eligible folks, that they receive daily overtime. So it's not in addition to the weekly overtime requirement. It just requires you to do more calculating, frankly, to determine if daily or weekly overtime results in the greater payment of wages to the worker. So the daily overtime threshold in Colorado is over 12 hours in a day, or over 12 consecutive hours from one day to the next if you have employees perhaps working overnight or closing and then opening the next morning. It also requires meal periods if you have non-exempt employees working shifts that exceed 5 consecutive hours. The addition to the comps order was that that meal period should not be in the first hour or the last hour of the employee's shift, if you can possibly make that happen. And it's supposed to be 30 minutes uninterrupted by duties. However, if your situation is such that you cannot give a non-exempt employee an uninterrupted 30-minute meal period that is unpaid, you can allow them to consume an on-duty meal and pay them for those 30 minutes of time. The rest periods also got a little different under the comps order. We always had a rest period requirement under the previous minimum wage order for those employers who were covered, and it's a 10-minute paid break in the middle or as close as you can get to every 4 hours of work. What changed with the comps order is that now if you miss a break, if you miss a rest period, the comps order says that you owe the employee another 10 minutes of pay, and another 10 minutes needs to be included in the overtime calculation for that day or that week. So that changed. Also, hours worked, what is considered work time, changed under the comps order. And we used to be able to, and still under the federal law, employers who are not covered by the comps order can exclude very small increments of time, like the time it takes to maybe turn on the computer and get that booted up. It might take just a minute or two, or the time it takes for somebody to punch in or something like that. So now employers, the private employers in Colorado covered by the comps order, do need to include in hours worked time spent by non-exempt employees in preliminary work tasks and after work tasks that take them more than a minute to perform. And there's some examples of what those might be in the comps order. And then finally, the comps order has some limitations on deductions and credits and charges you can make with your employees. So if you are a private employer, you have that poster up, make sure you understand those requirements too. And if not, get some further information on that. The other change from the comps order was to set a new minimum salary limit for employees to be exempt from overtime. So this has always been set at the federal level. We haven't had a Colorado requirement. We've just followed on to the federal requirement. And now we have a state requirement that exceeds the federal requirement. As of January 1, 2021, to be an exempt employee in the state of Colorado, the employee needs to be making a minimum of $778.85 per week or $40,500 per year. The federal requirement is $684 per week, and it's $35,000 and some change per year. So that is a significant jump. And it's going to increase 3 more times in the next 3 years, up to January 1 of 2021, when we will, or 2024, excuse me, when we will go back to annual increases adjusted for inflation. And at the end of this time, exempt employees will need to be making $55,000 per year. So you may not be affected by this initial jump, but you're going to want to be planning if you're going to be affected by subsequent jumps, because they are quite large and they are upcoming. So before we get into the Equal Pay for Equal Work Act, do we have any questions from the group?
Hi, Tina.
Hi.
So one question about the employee handbook. Does it have to be a separate page when they sign the handbook agreement?
It doesn't really say. The poster itself, I think, works best formatting wise on its own page, and then the acknowledgement to follow, but it doesn't specifically require that if you can make it work another way.
Okay. And we have a question about quarantine time. Are you going to talk about that later, and we can answer that question later?
I don't have planned to talk about quarantine time.
Okay.
So why don't we see if we have time at the end to go over that. But I did not have that in the works. We were just going to talk about the changes for 2021.
No worries. And then remind us what the annual salary will be at the end of the comps, and what the highest it's going to, and what date that is.
It's January 1, 2025, and it's going to be $55,000 per year.
Great. Thanks, Tina.
Yeah. And the weekly amounts to 1,000 and some change, and I can get that exact number and send that out to the group. I'll send you my slides, and I'll send a copy of the current comps order that has all the information in it, so that you can distribute it to the attendees today.
Thank you. That was my another question was, would we get a copy of your slides? So that will be great.
Yeah, everybody always wants that, and I know, and I apologize for not having it to you beforehand, but you'll have it after.
Great. Okay. Well, that's all the questions for this first section, Tina.
Okay. So the Equal Pay for Equal Work Act went into effect January 1, 2021. This actually passed in 2019. So it had some run up to it for us to get ready as employers. However, COVID happened and made that time a lot shorter, and we use that time in other ways. So we're finding that we're still getting at Employers Council a lot of questions about the Equal Pay for Equal Work Act. This covers all public and private employers. So public employers are state government and state political subdivisions, municipal government, and special districts as well under this. So the comps order, the public employers are not covered by. Now we're moving into a new law where all public and private employers who employ a person in Colorado, excluding just the federal government, are covered by the Equal Pay for Equal Work Act. And again, it did take effect Jan 1. It is not retroactive. So that means people cannot bring claims prior to January 1, 21 for equal pay violations. Only going forward are they able to do that. And it also covers all employees who work for, again, an employer who employs a person in Colorado. It prohibits pay discrimination based on sex or sex plus another protected status, like sex plus age or sex plus race or sex plus national origin. And we've all seen some of the statistics about what pay discrimination, what impact pay discrimination has on women and also women of color, even worse in many cases. That is what it's there to remedy. Now, you guys know that there's been an Equal Pay Act in place since 1963 in the United States at the federal level, but it's really thought that that has not moved the needle enough. So states, including Colorado, have passed more restrictive, frankly, pay equity laws. And Colorado is among 17 states that have done that in the last several years. It also prohibits asking about an applicant's wage history, or an employee's for that matter. But applicant is key in this new law. So we cannot, in an interview or in an application form, ask about prior pay. So that's something to change on your in your pre-employment processes right now. You can ask salary expectations or salary requirements. That is acceptable to do, and that is probably what you'd shift to if you did formally ask about wage history. It also prohibits relying on wage history to set future pay. So sometimes employers paid just what they needed to. They found out what the person made previously and added a little bit of money on top of that as the wage that they offered the person, and that won't work anymore. Because we do not want to perpetuate a previous employer's pay discrimination in that fashion. So we need to have a compensation plan. We need to have some procedure for how we value somebody on their way in. Many employers will have rates and ranges that they have set for certain positions. That's a good way to go about this, and use that as your marker for setting pay when you bring somebody on board. Of course, this new law prohibits discrimination or retaliation if applicants don't disclose their wage history to you, and it prohibits adverse action against employees for discussing wages. Now, you can still restrict your payroll person who knows everybody's wages from disclosing that, but individuals in your company can discuss what they're paid with each other and with third parties legally. And that's been true not just under this law, but under other laws that have been in place in the past. And finally, we cannot have an employee sign a waiver that denies their rights to discuss their wages with each other, with other employees, and with third parties. So with the pay discrimination piece, how do we compare jobs? The new law says job titles are not relevant, that you are to compare based on substantially similar work in terms of the skill that's required for the job, the effort that goes into the job, and the responsibility that the job is given. So we don't have any case law yet on this new statute that just went into place last month. So we haven't had this interpreted, but how these things are looked at under other state laws that Colorado's law was modeled after. We were actually modeled after Massachusetts. There's also one in California that's pretty similar. And under the federal Equal Pay for Equal Work Act, what they do tend to look at for skill is experience, ability, education, training that's required to perform the job. Then for effort, that's typically the physical or mental exertion that goes into that job. And finally, responsibility is that degree of accountability that goes with that position. So when you're looking at your jobs, you're going to be looking at these things and comparing them side to side. And to the extent that jobs are substantially similar, right, then we want to make sure we're doing a pay equity analysis among those jobs. Equal, of course, does not mean identical jobs. If there are minor differences, they're probably going to be considered substantially similar. And that won't render the jobs unequal. One of the things that's throwing us off as employers with this new law is they say that market data cannot justify that the market cannot justify pay disparities. And we're going to go into in the next slide what can justify pay disparities. So an example of how market affects us is, say we hired somebody in 2010 when we were coming out of the Great Recession. We probably hired them for less than maybe we would have hired them in 2019 when the economy was going great guns and there were very few skilled workers available, right? Sometimes we end up with compression in our compensation plans. We bring in a new person, we have to pay them more than people currently in the position in our company just to get them at that time because of where the market's at. That's going to be an issue under the new law. So we really do, again, need those comp plans to guide us, and we need to stick within our parameters of our hiring rates and ranges as we bring people on board, which is going to be tough, I know, for hard to fill positions. So what factors can justify pay disparities under the new law? These 6. And it can be any combination of these 6. It could be just one of them. So when we determine what our substantially similar jobs are, if we have employees of different sexes performing those jobs, we need to be able to justify any pay disparity by one or more of these 6 factors. So of course, seniority is length of service. If you use a merit system, you need to have, that system in place that prioritizes their ability, right, or their contribution in some way. So that needs to be made measurable for each position, and we need to evaluate the employee's achievement of those particular abilities in some neutral way, and then tie that to their compensation. So if we've sort of loosely defined merit in the past as sort of the gut check of who's our best and who's not our best worker, then you're going to want to be more formal about that and have documentation to support why one employee is getting a greater pay increase than another. We always needed that, but we need it even more now. Quantity or quality of production is another way we can measure performance. And to the extent that you have that and you tie that into your compensation, that can justify a pay disparity. Geography is an interesting one. We certainly know that cost of living is different parts of the state, different parts of the country for sure. If you use geography to differentiate pay, then again, I would make sure that you have that cost of living and other economic data that shows the difference from Denver to Colorado Springs or something like that. Education, training, and experience that's related to the work, right, is something that can justify pay disparity. So these are things to inquire about in job interviews. You want to keep people's resumes, and you want to verify their education if you are paying people more for these reasons. And finally, travel. So if travel is required for work, I know we're not doing as much of it these days, or at least most of us are not, but to the extent that travel is necessary for the work, then that could be a reason that pay might be different. The Act also requires posting of promotional opportunities, and there's more to come on this. We're getting a lot of questions about posting requirements under the new law. You also have record-keeping requirements. You have to have job descriptions for the employee, plus their wage rate history throughout their employment, plus 2 years. So don't panic if you didn't collect it before January 1, 21. Start now and collect it going forward. because the Colorado Department of Labor and Employment can fine employers at the low end $500, at the high end $10,000 per posting or record keeping violation. Employees have options when it comes to enforcing this law. They can go to either the Colorado Civil Rights Division or the Colorado Department of Labor and Employment to bring their pay equity claim or their claim that you didn't post or keep records or so on and so forth. But none of that prohibits them or requires them to use those processes first before going to court. So they can go directly to court and sue you there. And there is a 2-year deadline for them to file their claim. That deadline starts and restarts with each paycheck that is based on a discriminatory decision. So there isn't going to be, employees will have plenty of time, in other words, to bring their claim. So what can they recover? They can recover up to 3 years of back pay plus liquidated damages. So what do I mean by 3 years of back pay? That is the difference between what you paid the person and what you should have or could have paid the person, but for the pay discrimination that occurred in your company. So it is that difference only, not all of their pay for 3 years. Then liquidated damages would be an equal amount to the back pay, and that's assessed just as a penalty. And what the law says is liquidated damages is appropriate to compensate employees for the delay in receiving the amounts that they should have been paid. We'll talk about a way to avoid liquidated damages in just a moment. There are also equitable remedies, so not money, but we can get reinstatement, promotion, pay increase, and employees who prevail can get their costs for the litigation and their attorney's fees paid by their employer, which can be as much or more than the back pay. This is the defense against liquidated damages. So if you show your good faith, you would owe the back pay, but not the additional liquidated damages amount, which is important, right? We would rather not have that tacked on. So the good faith evidence is having conducted a pay equity audit within 2 years of the claim in your organization, specifically looking for sex-based disparity in your compensation system. So this law is really encouraging us as employers to be checking and rechecking our compensation systems to avoid sex discrimination. And they do say in some of the rules that followed the law that not keeping required records, we talked about job descriptions and pay increases for the life of the employee's employment plus 2 years. If you don't have those records when you're supposed to have them, that can be used as evidence of bad faith in an equal pay for equal work. So the posting requirements. This is the most technical, and I apologize for how technical this gets, but essentially employers who are covered by the law are required to post all promotional opportunities to their current Colorado employees. And we're supposed to do that on the same day as we do an external posting and prior to making a promotion decision. So you don't have to do an external posting, but you do still need to do an internal posting. So let me say that again. You're going to post all your promotional opportunities to your current Colorado folks. If you're posting externally, you want to make sure that posting occurs on the same day as the external posting. And you need to do this prior to making a decision. So you can use any method where all employees can access the posting. So online hard copy, and they need to be told where to find postings. So a lot of employers are doing that on their employment pages on their websites. So what's a promotion? We thought we knew, but Colorado Department of Labor helped us with this, and they've defined it very broadly. So obviously it's a vacancy in an existing or new position but it's one that could be considered a promotion. So that's pretty flexible language. That could be for one or more employees. So one, it could be just one employee that you're making this change with, in compensation, benefits, status, duties, or access to further advancement. So this does cover those inline promotional progressions that you have set up for employees, even though only one employee is going to be eligible for that, or only employees that meet those qualifications are going to be eligible for that. And that's one of the things we're getting a lot of questions about. So it's also when we make changes in an employee's current job. So they go further from promotional opportunity to define vacancy. And when we're talking about a vacancy in an existing position, this makes sense, right? It's when you have an opening that you intend to fill, right? Or the person in it is leaving and you're going to fill it. Also, it's when you have a new position, that is a vacancy. But then when you look at the bottom bullet, if you give an existing employee a new position by changing their job title and or materially changing their authority, duties, and responsibilities, or excuse me, opportunities, that is going to be something that needs to be posted as well. So that's that level of detail has come out of rules and guidance following the act that came out in December of last year. And some of that restructure and new jobs that we put people in a restructure are probably going to be covered and be required to be posted. What's not a vacancy, just a pay increase only is not a vacancy, thank goodness. Also, if an employee obtains an external degree or certification and we just add that to their job title, that is not a vacancy. So the posting has to be in writing. Again, it can be electronic or on paper, and include these 3 items. We'll talk about the compensation and benefits that must be included next. And we got to let them know how they apply for the position. So the compensation and benefits, the top one is a number. So we do need the hourly rate or salary rate or range, if there is one, that we would offer for the position. So this is not the full rate or range for somebody who might work in that position for years, but it is what we reasonably anticipate we would offer to a candidate for this job. So really hiring rate or range is what we're talking about. And then the next 2 are words. So we need a general description of bonuses, commissions, or other compensation that go with the job, and a general description of benefits. And the ones that we should include are healthcare, retirement, paid days off, and other tax reportable benefits. You do not have to include minor perks. So again, saying health insurance is sufficient. You do not have to get into values or details on your health insurance. So there are a few limited exceptions to the posting requirement. And one is where there's a compelling need for confidentiality. So the situation that's posed in the rules is where the employee who's currently in the position doesn't know that they're going to be separated yet. So we can wait until that happens before we post the position. Also, if we have an automatic promotion after a trial period that occurs in the first year after we hire an employee, if we reduce that to writing, then we do not have to post that requirement. So where would you put this in writing? You could put it in a policy. They'd also say you can put it in an offer letter or a contract. As an attorney, I would really think about putting a promotion in an offer letter or a promotion in a contract if you would not normally have a contract with that kind of employee. Finally, you do not have to post temporary acting or interim hires. So if you're just going to have somebody in there up to 6 months, you do not have to post that. But As soon as you figure out you're going to have that as a regular position, you do need to post that. There are some geographic limits. So again, the posting requirements do not apply to employees who are outside of Colorado. So that's why I said earlier, you post to your Colorado employees. So if you have employees other places, you don't have to post to them. And compensation posting requirements do not apply. So just the salary and the benefits information doesn't apply to jobs entirely outside of Colorado or postings that are entirely outside of Colorado. Now that last bullet's not super helpful because we're all posting online these days, or mainly most of us are posting online these days. So the posting is not going to be entirely outside of Colorado, but jobs to be performed entirely outside of Colorado do not have to have the compensation information included. So let's check in and look, how are we doing question-wise?
We've got a few questions. So I'm going to start with, for small businesses that have few small businesses have pay curved or defined pay ranges. How small of a business do these laws apply?
If you have one person in Colorado, you are covered. So you are covered. You don't have to have a pay curve or rates or ranges, but you do need to have some plan or structure for how you value jobs and how you set pay and how you increase pay.
Okay. How does it work if you want to give someone a promotion and you typically give a minimum of a 5% increase above their existing wage?
Well, again, you have the 6 factors for where you can have pay disparities. So if that increase is going to create that pay disparity, you need to base the increase on one or more of those 6 factors.
And if you reclassify an employee's position, do you need to post that role internally?
Well, and that's the tough part. And that's what we're getting a lot of questions about, right? So, because it says if we change a current employee's job title and or materially change their opportunities and duties and those kinds of things, then yeah, we are going to be subject to the posting requirement with the information we have now. So what you can do in your posting is make sure that you say that only qualified individuals will be considered, because you don't have to accept an unqualified candidate. This law is not about that. And maybe you even put in qualified people are people who have achieved this whatever marker.
Okay. Tina, do you have to list every potential benefit in the job posting? For example, potential types of PTO like bereavement leave, stuff like that?
I think it's good to break it out. Now you could, if your posting is getting really long, you could link to that on your internal page, right? Your jobs page, saying, eligible employees receive all the following. But they do break it out in the rule. So that's why I put that on the slide, what they specifically listed. And they do talk about vacation, sick leave, and I think bereavement might be in there as well. So I would follow what the rule says you need to include, and just write that in as concise a way as you can.
Okay, thank you. And are the hourly and salary audits to be performed by HR or HR departments?
It can be done internally, or you could engage somebody externally. It doesn't specify in the statute. So you can show good faith by doing your own internal audit of your compensation plan.
Great. Thank you. That is all the questions for this section right now, Tina.
All right, great. And I think we're doing good on time. It's 11:45. I think we have till 12:30. So the next section is going to be paid leaves. And we have a few of them in Colorado. And then we have, what I want to start with is one that's kind of carrying over in one sense from 2020, and that is the Families First Coronavirus Response Act. This is the federal law that passed last March and went into effect April 1st of last year, and required employers to provide employers with under 500 employees, which is probably everybody on the call here, to provide emergency paid sick leave up to 80 hours and FMLA expansion leave up to 12 weeks. The expansion leave was just for parents whose kiddos didn't have care or were out of school due to COVID-19. The emergency paid sick leave was for an employee having symptoms or having COVID or being quarantined by an agency or caring for someone, and also for parents with kiddos that did not have care or school. So we've been living with that, and that was set to end December 31st of 2020, and it did end as pertains to the entitlement to leave. So employees did not get a new entitlement to leave January 1 of 2021. What was extended, however, for eligible employers was the ability to, if we wish to, voluntarily extend any remaining leave an employee had left over from 2020 into the first part of 2021 and to claim those tax credits. So let me just be very clear about that. Employers do not have to provide additional Families First Coronavirus Response Act leave in 2021, as we are now. But if you wish to, you could give the employees whatever leave they have remaining from 2020. If they used it all in 2020, there is no remaining leave. If they did not use it all, you could allow them to use that. And if you are a private employer with under 400 employees or 500 employees, you could continue to claim tax credits for that paid leave that you provide to those employees through March 31st of 2021. All right. So if you're going to do this, of course, you're still subject to all of the rules that go with that leave. And I know you guys are watching the news and you're hearing things about the existing Congress or the current Congress thinking about another COVID relief bill. That might include an extension of Families First Coronavirus Response Act leave into 2021. That is not done yet. And of course, we're tracking that and we'll be letting members know if that occurs, but it's possible we could get an extension. And that would be an extension of the entitlement to leave as well as the tax credits. Right now, there is no extension of the entitlement to leave, just the tax credits. And if you're thinking about extending Families First Coronavirus Response Act leave into 2021, you have to be thinking about the interaction with Colorado's Healthy Families and Workplaces Act, which also provides two different types of leave. There's a paid sick leave component that employers with 16 and more employees became subject to January 1 of 2021. If you're a smaller employer with 15 or fewer employees, you are not subject to the paid sick leave portion of the Healthy Families and Workplace Act yet. But the state did trigger at the very end of last year the second type of leave under Healthy Families, which is the public health emergency leave, which is pretty similar, but not the same, of course. We can't have it be too much similar as the Families First Coronavirus Response Act emergency paid sick leave. So that public health emergency leave is a requirement of all employers in Colorado for the duration of the public health emergency in Colorado. And our governor enacted an executive order as of December 27th saying this is triggered, this public health emergency leave is triggered. That order was in place until January 25th, and we've had that extended now into February. So I think we can expect that that will continue. So let's talk about Healthy Families and Workplaces Act. So as again, the Families First Coronavirus Response Act voluntary extension notwithstanding, if you're going to do that, that doesn't relieve you from meeting your Healthy Families and Workplaces Act requirements. Employers with 16 or more, again, must provide the paid sick leave, and all employers must provide supplemental public health emergency leave. If you have existing leave that meets or exceeds the paid sick leave and the public health emergency leave requirements, then you do not need to provide additional leave. But it's probably something that you need to have looked at to make sure that your existing leave meets all the requirements. It's not just the amounts, it's also how it can be used, when it can be used, in what increment it can be used. And those are the things that we're finding in reviews of policies that need to be changed in existing leave that employers want to use to meet the Healthy Families and Workplace Act requirements. Again, no separate policies required, and employers can provide more time than is required under this law. The other thing that applies is the documentation piece. So this is also different from what you may do in your existing leave and what we could do under the Families First Coronavirus Response Act. So we can require documentation verifying the need for leave for use of the paid sick leave portion of Healthy Families if the employee is out for 4 or more consecutive work days. So Thursday, Friday, Monday, Tuesday, if they don't work weekends, or Monday through Thursday. So if you have a sick leave policy that says we can ask for a note at any time, and you're trying to use that policy to comply with Healthy Families, the documentation piece needs to be changed. Employers cannot require documentation for use of public health emergency leave. You can ask the employee why they need it, but you cannot require proof. So I know that that's something that is troubling to you as an employer, and you're concerned about abuse of this law, and that is the status. That is the status of the law. So for the paid sick leave, it's pretty standard for sick leave, how you can use it, right? When the employee or their family member is ill or injured or has a health condition, needs medical care or treatment, or needs that preventative care. That's pretty standard under most sick leave policies that employers might have. What may not be standard is that paid sick leave can also be used when the employee or family member is a victim of domestic abuse, sexual assault, or harassment, and can be used for any of these purposes as well. So you may not have that in your sick leave policy. That might be a tweak that needs to be made. Paid sick leave, again, for employers with 16 or more employees, right? It begins the later of, or the earlier of, January 1, 2021. So your current employees started accruing January 1. Anybody you hire will start accruing upon their hire from here forward. And the ratio for accrual for all employees, full-time, part-time, temporary, what have you, is 1 hour per 30 hours worked. If you wish, you can calculate what the employee would earn in a year and front load it as a lump sum and meet your requirement that way. The accrual and the grant cap is at 48 hours per year. So again, you can be more generous, you cannot be less generous than this. Employees get to use it upon request. They can request it in a lot of different ways. You can have your reasonable notice procedures, and employees should follow them for foreseeable leave, but you cannot deny the leave for non-compliance with those policies. Employees can use the leave as it's accrued. So if they're getting 1 hour for every 30 hours worked, they could use an hour in their first week of employment. So that's something to be aware of. and they can carry over up to 48 hours in a year into the next year. But again, use and accrual are capped at 48 hours a year. So if an employee earns up to 48 in 2021 and carries over a full 48 in 2022, they would not earn any more leave in 2022 because they are at their maximum. Employers do not have to pay out unused Healthy Families and Workplace Act leave upon separation. If you rehire someone within 6 months, you need to reinstate what they had when they left of Healthy Families and Workplace Act leave, unless you did pay it out at separation, and then you don't have to do it. Public health emergency leave. So this is everyone. The paid sick leave is just this employers with 16 and more. Employers had to, as of January 1, 2021, supplement the employee's existing leave that could be used for sick leave purposes, whatever you called it. You need to just supplement that leave up to 80 hours for full-time employees. And then there's a prorated amount for employees who work less than full-time. And this can be used for these reasons. When the employer or their family member, right, this is where it looks a lot like the Families First Coronavirus Response Act, has to isolate due to COVID-19, has to seek medical diagnosis or has symptoms of COVID-19, seeks preventative care for COVID, and has been determined to be a potential jeopardy to other people's health. So that's the exposure kinds of cases. And when the employee has to care for a child or a family member. So that's an extension, not just kiddos in this law, family members whose school or place of care is unavailable due to COVID. Employees can take leave for that as well. So family member could be elder care kinds of issues besides just kiddos. All right, so I do want to mention Proposition 118, and mostly what I want to say is this is not here yet. So we've already got it complicated enough between the Families First Coronavirus Response Act and the requirements of the Colorado Healthy Families and Workplaces Act. So let's just not worry so much about Proposition 118 as yet. This is what the family bill turned into. There was a bill called Family that was proposed in the last 4 Colorado legislatures, and we really thought 2020 might be its year to pass, but it sort of fell apart at the beginning of the session. It lost some sponsors, and the people that wanted to put this in place in Colorado decided to take it to the voters. So last November, we voted on Proposition 118, which is what became of the family bill, and it passed. So the first leave will not be taken under Proposition 118 until 2024. The first deductions for the taxes to support Proposition 118 will not be taken until 2023. So we have a little time to figure this out, but we've got a lot of questions about this. This would provide 12 weeks, and there's a kicker that would add another couple of weeks in some situations of paid time off for employees. And the reasons for leave would be similar to the Federal Family Medical Leave Act. So for those of you who are not covered by that law, that is when the employee has a serious health condition, when their spouse, parent, or child has a serious health condition, although this is broader than just spouse, parent, or child. It also includes some other family members as well, need leave. So the pay would be at a percentage of the employee's wage and no more than 90% of their wage, capped at $1,100 per week. So this is going to be a state-run system that would be funded by a payroll tax. Half of that tax will be paid by employers. The other half will be paid by each employee. So again, they're not going to start taking those taxes until 2023, and there'll be a year of taking those taxes before anybody can receive any benefit from this law, so they can build up the state fund for Proposition 118. Employers with fewer than 10 employees are exempt, and employees become eligible for the program after earning $2,500. So pretty quickly after they come on board, they would become eligible for taking advantage of this benefit. And it also has a job protection. So if somebody becomes something other than an at-will employee, in that they need to be restored to their job if they've worked for you for 6 months or more at the end of their leave. Again, we don't have all the particulars of this. There's going to be some caveats there. So I wouldn't spend too much time worrying about this yet. And I would administer the families first if you're doing that, and healthy families right now. Employers will have the option to purchase private insurance instead of participating in the state system. And then, of course, there isn't going to be the tax deducted from the employee's pay. The employer will be purchasing that and footing the bill for that. So where are we on the paid leave laws for questions?
Hi, Tina. Okay, so I'm going to backtrack a little bit. Is the mandatory sick leave policy for workplaces with over 16 employees, does that include both full-time and part-time employees?
Yes, it actually includes all employees on your payroll in the United States, even ones on leaves of absence. So if you had one person in Colorado, but 15 people in Wyoming, you would need to offer that Colorado employee full-time or part-time paid sick leave under the Healthy Families and Workplaces Act.
Okay, and if you start the year with less than 16 employees and then later on you reach 16, how does that work? Do you have to go back to January 1st, or does it start when you reach 16?
You actually get a little bit of lag time. So this was a question when the law passed and some of the rulemaking clarified. They're following the rule under the Federal Family Medical Leave Act that when you hit the threshold, in this case 16 employees, you then have 20 weeks to get yourself ready to go, and before you need to provide Healthy Families and Workplace Act leave. So you have a 20-week window of time from the point that you hit 16 employees to get yourself ready and start that process.
Okay, and does that paid sick leave have to be paid out if the employee quits or gets fired?
It does not have to be paid out if at separation, whether it's voluntary or involuntary. But you do, if you reinstate the employee, such as in a voluntary resignation, within 6 months, then you would reinstate what that employee had when they left.
Okay. And an employee that carries over 48 hours of unused paid sick leave into a new year does not earn an additional 48 hours?
That's correct, because they're at the maximum.
Okay. And if you allow an employee to use CARES Act and submit for the federal tax benefit, are you then also required to allow the same employee to utilize the Healthy Families Work Act up to 80 hours? So an employee could receive 80 hours under CARES and 80 hours under the Healthy Families Work Act for 2021.
That's not answered in any good way, unfortunately. So I don't have anything to point to that says you're not also subject to the Healthy Families and Workplaces Act in the full amount. So we are saying, I mean, we've seen some articles that say you could count them both. That's not typical, right? With paid leaves, they usually do not overlap. Like unpaid leave might overlap with a paid leave, but we haven't seen that. And so we are saying that it could be both Families First Coronavirus Response Act leave and the Healthy Families and Workplace Act leave.
Okay. And
so we'll see if we get anything more on that. But right now we're saying, yes, you're subject to both requirements.
Thank you. And how is this type of leave calculated for tipped employees? Is it calculated the same way?
I won't get into the particulars of that in this call, but there is some instruction on how to do that calculation. And I can share that with you if you want to send Angelica your information. I can respond to you with that information.
Yeah, I think that'd be great. I can send that out to the group, just include it in a follow-up email with your slides.
So I'll add that to my list of comps order, slides, and healthy families tipped employees.
Thank you. And that's all the questions on that part so far, Tina. Thank you. Okay,
we've just got one section left and we've got 24 minutes. So the public health emergency whistleblower is another law that went into place in July of 2020. And this is one that really kind of snuck under everybody's radar because we were in the midst of all things COVID at that time. So I just want to make you aware of it. It's those whistleblower statutes are difficult ones for employers to defend. And we are getting a lot of employees who are fearful, right, of being in the workplace, who are coming to us saying that we're not doing enough or they don't feel safe. And that is what could potentially trigger this statute or a claim under this statute. I was on a panel for Colorado Society for Human Resource Management at their annual conference last year. And Madeline Collison, who's a well-known plaintiff's attorney, was on that panel as well with me and another management side attorney. And she said that this law was pretty intriguing to her because she was getting a lot of calls in her practice about people who were saying, I don't know that my employer's doing everything that they need to be doing. So that sort of pricked up my ears, and that's frankly why I'm making sure everybody knows about this statute because it's not advertised. It's not like all of you have time to track the legislative session and know what's going on. So this is what it is. It was effective July 11th, 2020. It covers employers, all employers, so public and private, and businesses in the state that contract with 5 or more independent contractors. So this even goes beyond employers in the state to certain businesses that engage independent contractors. And it protects workers who raise good faith safety complaints. So good faith means, they've got to have a reason to believe that this is a problem, but they don't have to be right that it is a problem. So we really do have to have an open door to our employees to come forward with safety complaints. There's no minimum threshold for how many employees you have to employ to be covered by this law. One is going to be enough. It also protects workers who wear their own personal protective equipment in certain circumstances. So again, depending on the kind of hazards that your employees are exposed to, you may be subject to personal protective equipment requirements of the Occupational Safety and Health Administration. So again, that covers private employers in the United States. And again, if you have airborne hazards, you might be required by those standards to have respirators or certain types of masks versus just a facial covering, which is the requirement in Colorado for all critical businesses, all businesses and government operations. So you have to allow them to wear their own personal protective equipment if that personal protective equipment provides a higher level of protection than the equipment that is provided, is recommended by federal, state, local public health agencies, and doesn't render the worker unable to perform their job or their job duties. So it is narrow. It's not, there is some analysis here that goes into that, whether they can wear their own personal protective equipment. It also, of course, protects workers who bring to your attention, right, what they think is an unlawful practice or if they even take it further than an internal process and they make an OSHA complaint, or they testify or assist or participate in a safety investigation of your workplace or some other kind of proceeding or hearing. As a practical matter, OSHA may take that complaint and they usually send an employer a letter, again, if you're a private employer, to notify you of the complaint and give you an opportunity to respond. Of course, if it's a grave concern, they may, without notifying you first, show up, usually with a subpoena, to come in to your workplace and check to see if you are following all the applicable standards. Of course, if you're an employers council member and OSHA comes knocking, please do give us a call. We do have health and safety attorneys on staff to help with these OSHA investigations and any following complaint. So the protection under this law is lost if a worker brings information forward that they know is false, or they are reckless about the truth or falsity. So what does it mean to be reckless? It's just, you're not very careful. Like you heard it from an unreliable source, or what you repeated was not what that reliable source actually said to your employer. So again, they don't have to be right. They just have to be reasonable in making a complaint. So that is what I have for you all today. So if we have any questions from any of the sections, I'm happy to take those. Or if you need to sign off and you want 18 minutes of your day back, you certainly can have that. Do we see any more questions?
Hi, Tina. I don't see any more questions. I will hand it over to you and Vic.
Thank you.
All right, then if we don't have any more questions, again, thank you everybody for attending today. And we will get Tina's slides and a little bit more information to some of those questions out. But feel free, if you have any follow-ups down the road, you can email me, vic@steamboatchamber.com, and I can forward those on to Tina for answers at a later time. So thank you, Angelica, for your help on the questions. And thank you very much, Tina, for providing all this great information today.
Absolutely. You all have a great day.
All righty. Thank you. Bye, everybody.